Saskatchewan is taking the Canada Revenue Agency to court over the federal carbon tax. It comes as the CRA asked the province to pay up a whopping $28 million. That's how much the agency says Saskatchewan owes in dues after it stopped collecting the carbon tax from residents in January this year. The province's Ministry of Justice has filed for an injunction to stop the federal government from taking that money, calling that move unfair and unconstitutional. National Revenue Minister Marie-Claude Bibeau responded to Saskatchewan's pushback in a statement on Thursday. Bibeau said the government of Saskatchewan chose to step into the role of a registered distributor, obligated to adhere to the law like any other. The CRA is on the case and has pursued collections as required by law. We stand firm in upholding the law and will continue to deliver the full Canadian carbon rebate to the people of Saskatchewan. Saskatchewan Minister of Justice and Attorney General Bronwyn Eyre joins me now. Minister, it's good to see you again. Thanks for taking the time.
Lovely to be here, David.
You stopped collecting the carbon tax on home heating in January. The federal government said they were going to send this to the CRA, so this move cannot come as a surprise to you and your government.
Well, I think what comes as a surprise is the garnishment part of it. And when we talk about unfair, certainly we feel it's that, but it is also unconstitutional. Section 126 of the Constitution Act 1867 says as much. Basically, the federal government cannot garnish or forfeit the funds in our revenue fund, our central revenue fund, and that is very, very clear. So there's a process under the legislation that governs the carbon tax for this type of thing, and
right.
We were following that and going along with that, and feel we have very strong arguments within that. But this is a different situation, and therefore the judicial review and the seeking by Saskatchewan for injunctive relief to stay that garnishment, and we continue to do everything in our power to do that.
But you say it's unconstitutional for them to go into your revenue fund to take money, but it's their revenue in the revenue fund because you have stepped in as the official agent your government has responsible for remitting the carbon tax to the federal government. So they're entitled to this money under law, are they not?
But not under Section 126. You cannot garnish, which is exactly what is happening and what the Canadian Revenue Agency is doing. And again, I mean, that's a very fundamental principle. Section 125, that one level of government cannot tax another. Section 126 cannot garnish the central revenue fund of a province, and that is very clear. As I say, there is a process under the legislation that governs the carbon tax for there to be a seeking of funding back, if you like. And as I say, we are following that process. That's a tax process. Ironic, because this was never supposed to be a tax. But there is a process, and as I say, we were in the process of working through that and believe we have very strong arguments as a part of that, particularly as relates to fair application. And certainly we've made that point before. I mean, if you have one part of the country which is exempt from paying the carbon tax, and another part of the country which is trying to extend that same exemption, you don't really have a national system.
Well, it's not one part of the country that's exempt. It's one type of fuel that is exempt. And I know proportionally, as a share of the population in Atlantic Canada, there's more oil burners there, but nominally, there are actually more people who use home heating oil outside of Atlantic Canada than there are in Atlantic Canada. And I accept the criticism that this was done for political reasons. I'm not arguing that, but just it is an exemption for a type of fuel. But to take your constitutional argument to its extreme, you're defying federal law to collect this tax and remit this tax. And if you now say the revenue that is supposed to go to Ottawa is sitting in your bank account that is shielded constitutionally, you can see where that can lead, can you not? That provinces right across the country can refuse to send things to the federal government they're supposed to, keep it in their bank account and say, too bad.
Well, I think there are a number of things there. I mean, first and foremost, I mean, the fair application of the law, one of the most ancient precepts of the law, of course, is its fair application. Keep in mind that when the carbon tax was argued at the Supreme Court justices raised explicit concerns about precisely this, David. Regional favoritism, picking of winners and losers, and anything that strayed from the concept of minimum national standards. That was the basis for the carbon tax. As soon as they decided to carve out an exemption to primarily Atlantic Canadians, I mean, let's be honest,
Sure.
then that began to unravel precisely as predicted and feared by the Supreme Court justices in the carbon tax decision. So, you know, the whole premise of this was minimum national standards and minimum national price stringency. That is now absolutely in question. As a result of the Atlantic carve-out, we had the explicit acknowledgement of that when we were told out here in the West to elect more Liberals and we might get exemptions too. That is not how it was supposed to play out, and that created a great trickle-down effect, if you like, to the demoralizing factor, not only for the province of Saskatchewan, but for taxpayers across the country. It fell apart.
I get the political argument you're making, you know, as a carbon tax opposing government and a carbon tax opposing province. I get that political argument, and I get your criticism of how they're following what you interpret as the meaning of the Supreme Court decision. But that feels like the opportunity for another legal challenge or an alternate legal action instead of you as the Minister of Justice and Attorney General and Premier Scott Moe breaking the federal law by not collecting the federal tax and remitting it to the federal government. This is almost like a legal vigilantism as opposed to following a legal recourse or beating them at the ballot box and having it repealed that way.
Well, it's about the fair application of the law, and it's about the fair application of that same exemption which was extended to Atlantic Canadians to the people of Saskatchewan.
But anyone who burns oil in Saskatchewan gets this exemption, right? You are choosing as a government that has to uphold the laws of Canada to not collect a federal levy, right?
We are saying to the federal government and to anyone else who will listen, but also to the citizens of this province, that because 85% of the citizens of Saskatchewan rely on natural gas for their home heating, they deserve the exemption as well. And again, I think that there are a number of parts to this. I think very important to keep in mind what legally the original intention was and what was undermined by that exemption. We were paying it. We didn't like it. We've never liked it. But we were collecting it until then. And when that happened, when it was pure political expediency, which came into the legal, if you like, mix and constitutional mix, that became a different matter. And now we're seeing garnishment by the CRA of a provincial consolidated revenue fund of a province who is trying to extend the same exemption to our citizens as was extended in Atlantic Canada. They get a break, and I support that. We support that. Right. We get our funds, our bank account garnished. It's simply not right in the spirit of any kind of cooperative federalism.
But it's also not right that a provincial government can make a change to a federal tax. They cannot come in and say, we think your sales tax is too high, and the federal government just decide to change it. They cannot say, we think your income tax rates are too high, and after everything is collected by CRA, refuse to remit things to you as a provincial government, you know, under the common filing system. So you know you're butting up against your legal authority by refusing to collect this, right?
Well, and keep in mind that, as I said, there is a process under the carbon tax legislation for precisely this, a dispute, in which case there is a governmental dispute. There is a disagreement on the basics, and we were in the process of arguing that and continue to argue that. That will eventually make its way to a federal tax court and likely beyond. So the point is that we made our arguments and have been making them, and we believe they're very strong. Not only on the fair application of the law and how that was absolutely undermined, or the idea of minimum national standards, which was undermined, which the Supreme Court was absolutely clear on, but also, you know, a number of other constitutional arguments which we feel are at the root of that tax dispute around, for example, the ability of the federal government to come after provincial crowns. That was something that wasn't really fully canvassed at the Supreme Court. So we're making those arguments, and we're making them legally, and we're going through the process, which, as I say, will make its way through the federal tax court process. What we were not expecting is to be targeted, punished, and bullied through garnishment, which they cannot do under Section 126. They can't do it.
Well, if Sask Energy had stayed as the registered agent for the remitting of the carbon tax, they'd be coming after them the same way, right? I mean, this is, if it's your job to send them the revenue, you put yourself in the crosshairs of the Canada Revenue Agency if you don't send them the revenue, do you not?
Well, we took responsibility for it, absolutely, as you've described, in terms of being directly, taking it over in terms of the collection. That's correct. Garnishment is a different issue, however. No. Garnishment is a different issue.
Well, you've just criticized them, just as a final point, Minister, for doing the home heating oil exemption for political reasons. And I would think even Liberals would accept that that is probably a fair criticism. But the rebuttal is that you're facing an election this year and that you're doing this for political reasons as a government. You don't like this, you got an election, this is a galvanizing issue to fight the federal government while offering something to your voters. I mean, how is it any different, what you're doing?
Well, I'd bet you $28 million that it has nothing to do with the election. It has to do with fairness. It really does. I mean, our position has always been very consistent on the carbon tax, love it or not. We've been very clear all the way along. Before this premier, it was Brad Wall. We took it to court. We lost. We were collecting. But when one level of government decides to reward one part of the country and punish another, that is precisely what was not supposed to happen and precisely what the Supreme Court justices warned against. And as the government of this province, we simply could not allow political expediency to trump what was a tax we never liked, but which we were going along with until they made it political.
Okay, we're going to have to leave it there. It feels like this will be argued in court and maybe in some elections. Saskatchewan Minister of Justice and Attorney General Bronwyn, thanks for your time today.
Always a pleasure, David. Thank you.